So as I wrote about earlier, the City Council tonight voted 8-1 to grant the tax abatement for the retail and condominium project. Now during the public hearing session, Greg Leatherman, who's the director of the redevelopment department, came forward and spoke in favor of the project, but he made a statement that was a little bit misleading, and to the council's credit, they did actually catch this and call him out on it later. So I want you to watch this real quick, and then we'll come back later and you can see where the misstatement was.
Essentially what we're looking at here is a tax abatement application. While it says $20 million, it is on the retail portion of that property.
Okay, so as you can see, Leatherman basically says that the $20 million abatement is going to apply to the retail portion, and there really wasn't a lot of discussion about the condominium portion. I mean, we'll get to that too here in a minute, but I guess I want to focus on that one aspect where he said retail and $20 million. Now later on, when Alyssa McGauley is discussing this tax abatement in detail, Councilman Harper and Councilwoman Goldner kind of stop her and say, you know, what you're saying really doesn't mesh with what Greg Leatherman said earlier. So they call Leatherman back to the table and basically ask him, you know, does this apply to just the retail portion as you said or not? And Leatherman provides his response. It's really a little bit different than what he originally said. So go ahead and watch this.
Comment are you referring to?
You said it was retail only?
Yeah.
I wrote it down.
Yep. What I said was that at the end of the day, when the condos are owned by individual owners, the tax abatements will flow to the owners of the condos, not to the developer. The developer will continue to sustain a tax abatement on the parts that they own, which will be the retail portion, the first floor. But the condos that will be owned by individual owners will be the beneficiaries of the tax abatement, not the developer.
Okay, so now let's focus on the pass-through of the property tax abatement from the developers to the condominium owners. The city maintains that this is going to happen, that a large portion of this $20 million abatement is going to flow through from the developers to people that purchase the condominiums. Now, Mitch Harper asks a question essentially saying, is this legal? But pay attention to how he phrases the question. He says, you have requested legal assistance on this. Have you received an opinion? This immediately raised the red flag to me that suggests the city has actually gone out and hired outside counsel to address this question. And let's see what they have to say about this. Notice that they kind of hedge and don't answer his question.
You have requested legal assistance on that? Have you received an opinion?
No.
Regarding the transfer?
Regarding the issue of the transfer
The transfer
to the residential buyer.
Yeah, the assessor's office has indicated, well, the auditor's office has weighed in on that, and it is up to them to decide whether to apply the tax abatement to those individual properties or not. It's in their jurisdiction to make those decisions.
You're saying that's discretionary with a public officer?
It's not discretionary. It's, like I said, Indiana code allows for both the homestead credit as well as the ERA deduction, and it provides a setup for how that flows. The deduction for tax abatement purposes would be taken off first, and then following the homestead credit after that. And that's as far as we've gotten with that process because this project is not built as of yet. So.
Councilman
Yeah, my question is that you say the law allows it, but does it require it? Do we have a guarantee here that the homestead credit would go to the new condominium owner?
As long as they're eligible, yes.
As long as
they apply through the new owner applies, and it all is predicated, upon state law, and then they take ownership.
Okay, so what they didn't tell you there in the kind of hedging and, it's up to the auditor, it's discretionary. I mean, they really didn't have a true legal opinion. And the reason why, as Fort Wayne Politics has learned, is they requested legal assistance or a legal advisory opinion from ICE Miller, the same company that represented the city for the DLGF retroactive property tax increase that was denied. So they go out and get the same firm that provided them the rationale essentially to go to the DLGF, and yet that firm hasn't responded back. So the city is moving forward basically with no guarantee or no information or legal opinion that this abatement is really going to flow through from the developer to the condominium owners. So that's very important. They're claiming this is going to happen, but there is no guarantee that that's going to take place. Now, I obviously disagree with the idea of giving tax abatements to people that own $300,000 properties. But that's really beside the point. We here at Fort Wayne Politics, we wanted to provide you with maybe a little bit of insight that you wouldn't get from watching the broadcast last night or reading the articles in the paper today. So we hope we've been able to share a bit of information that maybe wasn't readily available beforehand. So I'm Jeff Pruitt with FortWaynePolitics.com, and we'll see you next time.